business before the Honorable Wabash College Moot Court drawn near, for the court is now in session. The Honorable Justice Baker, Fisher, Watson, and Hyman presiding. Be seated.
Good evening and welcome to the 22nd Annual Wabash College Moot Court Competition, an annual event that's co-sponsored by the Rhetoric Department and the Indianapolis Association of Wabash Men. We had another invigorating contest this year featuring 25 students who participated in the preliminary round. The judges in the competition, its various alumni and faculty, were once again impressed with the skill, advocacy, and dedication of the students during the preliminary rounds. From there, we moved to 12 students in the semifinal rounds that were conducted last night, and those were intense rounds with very difficult decisions. The decision from last night left the 4 students who are sitting here before you this evening to participate in tonight's finals round. Before introducing the advocates, I would like to welcome our guests from Lawrence North High School who are here as part of a law and government course. They're waving a little bit. They will actually be arguing this same case in their class, and we've been delighted to have them here the last several years and work with their program as well. I also want to thank all of the students, alumni, staff, and faculty who are involved in this year's competition. In particular, I would like to thank the Planning Committee for their continued dedication to the program, including Scott Himsel, Matt Griffith, John Pachter, Seamus Boyce, and Rick Pitts. I'd also like to thank a variety of staff here at Wabash College who support the program every year, staff such as Mindy Mills, Philip Marriott, Adam Phipps, alumni and parent relations, Bon Appetit, campus services. They all play an important part in allowing us to have the competition each year, and we thank them. I'll now introduce the finalists, after which Professor Himsel will introduce our judges, and then we will proceed with the oral argument. Tonight, representing UCLA, and advocating on behalf of a group of religious organizations that oppose some requirements of the Affordable Care Act, are Matthew Bender and Benjamin Wade. Matthew Bender is a senior from Hobart, Indiana. He's a classics major and a history minor. He's a member of Kappa Sigma, and among his various campus affiliations include the Glee Club, Eta Sigma Phi, and Sons of Wabash. After graduating from Wabash, Matthew plans to attend law school. Tonight, he will be making the substantial burdens argument for the petitioner. Joining Matthew is Benjamin Wade. Benjamin is a junior political science major and history minor from Clayton, Indiana. He's a member of Phi Gamma Delta. Among his various activities on campus, he's a member of the Student Senate, a member of the Glee Club, participates in Model UN, and serves as a writing center consultant. After Wabash, Ben plans to attend law school and focus on either criminal or international law. Tonight, Ben will be making the Hobby Lobby portion of the argument for the petitioners. Please congratulate Matthew and Benjamin. Representing the respondents, that's the government, who is arguing to affirm the lower court ruling upholding the Affordable Care Act, are Derek Andre and Adam Alexander. Derek Andre is a senior from Sullivan, Indiana. Derek is a political science major and a double minor in rhetoric and business. Derek's activities include Model UN and Sons of Wabash. After Wabash, he, say it with me, plans to attend law school. Tonight, Derek will be making the substantial burdens argument for the government. Finally, we have Adam Alexander. Adam is a senior political science major and economics minor from Yorktown, Indiana. He is a member of Phi Gamma Delta, where he is the recording secretary. Adam is editor-in-chief of The Bachelor, president of the Pre-Law Society, and president pro tem of the Student Senate. After Wabash, Adam plans to attend law school. Adam will be making the Hobby Lobby portion of the argument for the government. At this time, Professor Himzel will introduce tonight's judging panel.
It's my pleasure to introduce our panel of distinguished judges. Serving as our Chief Justice tonight is the Honorable Tim Baker, Magistrate Judge of the United States District Court for the Southern District of Indiana. Judge Baker earned his undergraduate degree from Indiana University, his law degree from Valparaiso. He has had wide-ranging legal career as a lawyer in private practice at Barnes & Thornburg, an assistant United States attorney, and since 2001, a magistrate judge. Judge Baker has been recognized for excellence in legal education, including appointment by Chief Justice John Roberts of the U.S. Supreme Court to chair the Federal Judicial Center's Magistrate Education Committee. Next on our panel is the Honorable Stephen Hyman, Judge of the Bartholomew Circuit Court in Columbus, Indiana. Judge Hyman graduated from Wabash in 1977 and was a member of Tau Kappa Epsilon fraternity. He received his law degree from Indiana University's McKinney School of Law in Indianapolis. He engaged in the private practice of law of Columbus before taking the bench in 1991, and like Judge Baker, he's been recognized for excellence in service to our profession, including the Kinsey Award for Outstanding Judicial Service and Support to the Children of Indiana. Also on our panel this evening, in our alumni position, is the Honorable Thomas M. Fisher, Solicitor General of the state of Indiana. Solicitor General Fisher graduated from Wabash in 1991 and participated as a member of Kappa Sigma fraternity. He received his law degree from IU Maurer School of Law in Bloomington in 1994. After private practice in D.C. and Indianapolis, Solicitor General Fisher was appointed a Deputy Attorney General and then as Indiana's first Solicitor General in 2005. As our Solicitor General, he has represented our state in a wide variety of courts, including 3 appearances before the United States Supreme Court, and on 2 occasions he's won the Best Brief Award from the National Association of Attorneys General. Our final panelist is Professor of Theater Dwight Watson. He's been a beloved and highly respected professor at Wabash for 34 years, taking his degrees at the University of North Carolina. At Wabash, he's taught acting, dramatic literature, and playwriting. He's directed more than 40 productions, including such legal classics as 12 Angry Men and Inherit the Wind. He's taught a seminar about the lawyer as storyteller in the courtroom and the stage. He's also a playwright in his own right. And Professor Watson now serves as the Distinguished La Follette Professor in the Humanities and won the college's Excellence in Teaching Award this year. Get this back.
All right, we are here today for the case of United States of America versus United Compatriots and Legal Allies, Inc. Is counsel ready to proceed? Yes? Yeah. May I hear your argument?
Mr. Chief Justice, and may it please the Court, my name is Matthew Binder, and I will be representing the petitioners in this case. Your Honors, our clients are being forced into a position in which they must either pay substantial penalties or facilitate access to abortions, to which they firmly object on religious grounds. There are 3 primary signs that indicate that this is the case. First of all, individuals must be allowed to define their religious exercise for themselves. This is not the business of courts or governments to decide. Secondly, the language of the Health and Human Services regulations themselves, using words such as complying with the mandate, actually indicate that this is in fact the case, that our clients are facilitating access to these contraceptions. And thirdly, Your Honor, the actual effect of the actions our clients are forced to perform is to facilitate access to contraception. In the Thomas case, this court ruled that the court is not only not within the judicial competence of a court to decide what the religious exercise of an individual is, but the court is in fact singularly ill-equipped to make scriptural interpretation.
I'm wondering about
Yes, Your
description of facilitating
Yes, Your
the
Honor.
access to contraception. Let's just get down to brass tacks. I mean, you have to sign a form and submit it, right?
That's correct, Your Honor. You do have to fill out a form.
And as opposed to paying for it. which
Absolutely,
I think
Your
is an exemption from the normal rule.
Correct, Your Honor.
Sounds like a kind of a reasonable accommodation. You have to tell the government if you're not willing to pay for the contraception so somebody else can take it up for you. What's the big deal?
Your Honor, I think the big deal is that the court is deciding, or the government rather, is deciding what is reasonable for our clients. And our clients must be allowed to decide what is their sincere religious exercise. And they don't want to be involved in any actions that leads to facilitating contraception. And that fits the jurisprudence of this court in the Hobby Lobby case.
What if it were simply a matter of a different kind of form? Maybe it's something that, well, we certify to the IRS at the end of the year that we've met all of our obligations as a nonprofit, something like that. And because they've signed that, then certain other things occur, and one of their employees gets contraception coverage through an intermediary. Does that present the same problem?
It does, Your Honor, if that form eventually triggers these women or anyone getting contraceptive coverage, because our clients object to partaking in any actions. And as this court has said, the argument that their action is too tenuously related to the actual outcome of someone getting contraception is not something for this court to decide. All this court needs to decide is whether or not the burden is substantial and whether or not the belief is sincere.
Well, excuse me,
Yes,
but
Your Honor.
isn't that what was decided in the Hobby Lobby case, that the action was too attenuated by the government, and that was overturned then? But I don't know what action it is specifically that your clients are entering into that you say facilitates. I understand they're filling out a
Yes, Your
form.
Honor.
I understand they're filling out the form. But what if the government required every employer who must provide health insurance of some sort to their employees to fill out a form, and regardless of whether they were seeking the accommodation or not, and they just had a box. One box said, we need the accommodation because of our religious beliefs. The other box said, we don't. How would that be a substantial harm or burden to your client?
Your Honor, it's a substantial burden because they have to fill out a certification. They have to take this affirmative act. And the form itself, under the Health and Human Services regulations, even says that the form itself becomes an instrument under which the plan is operated. And under ERISA law, for instance, third-party administrators are not legally authorized to pay for this contraception. A self-insured plan cannot be modified without a written document, Your Honor. So our clients are very much partaking in an action that is necessary for these women to receive contraception, and that, Your Honor, is how they are being forced to facilitate contraception.
Well, what's the burden? Filling out the form?
Your Honor, the burden is the choice that our clients are being forced to make what is to them either two decisions that both are against their religious beliefs. They must either pay for contraception, to which they object on religious grounds, or fill out this accommodation.
Fill out a form. How is that a substantial burden?
Because, Your Honor, it facilitates access to contraception. It's an affirmative act that they are being required to take. The language of the Health and Human Services...
They don't supply the abortions.
That's correct, Your Honor.
They don't supply the birth control.
That's correct, Your Honor. But again...
Fill out a form. You have to show a substantial burden. I just don't know how that would be a substantial burden. If you go get a driver's license, you fill out a form. If you want a gun permit, you fill out a form. How is that a substantial burden?
Yes, Your Honor. It's not so much the act of filling out a form to which they object. It's what that act is a part of. It's the fact that they're being forced to participate in this scheme. They have to fill out this form, and then the form itself becomes a plan under which contraception is provided, and it legally authorizes third-party administrators, for instance, to pay for this contraception.
Now, the decision below made a point. I wonder if you'd respond to it. It says, or maybe a pacifist refuses to complete a form to indicate his beliefs because that information would enable the Selective Service to locate eligible draftees more quickly.
Yes, Your Honor.
Is the majority wrong about that?
Could you rephrase that a little bit, Your Honor?
Well, the majority opinion indicates that, taking issue with your argument, it's that maybe a pacifist who refuses to complete a form to indicate his beliefs because that information would enable the Selective Service to locate eligible draftees more quickly. I mean, there's nothing wrong with that, is there?
Your Honor, there is an exception to REFRA, and so perhaps that case could be acceptable under the exception to REFRA, that there is a compelling state interest there, and that's the least restrictive means available, even if this court does find that that is a substantial burden under our argument. Your Honor, I think that it is certainly a substantial...
It's an interesting point, though, because in Hobby Lobby, the majority opinion specifically noted that this system that applies to religious nonprofits, not the churches, but to the religious nonprofits...
Correct, Your Honor.
...was, in its mind, a more narrowly tailored way to approach the problem of contraception for businesses that object. Seems like they've kind of answered the question on whether there's an accommodation there.
Yes, Your Honor. The court did not actually make a ruling about the accommodation, though, because that was not relevant to that case. Since Hobby Lobby has a for-profit corporation, was not offered the accommodation. They simply had to either pay for contraception itself or pay substantial fines, which immediately it was agreed that that was certainly a substantial burden on their free exercise. So the court did not have reason to really consider whether the accommodation was a substantial burden or not, as it needs to today. And
no, but I guess that's assuming that there's a substantial burden. I mean, regardless, if we come to the conclusion that this is sufficiently narrowly tailored,
and to pursue a compelling government interest, it doesn't really matter about substantial burden.
Your Honor, if this court did find that it was the least restrictive means, then it would be acceptable, Your Honor. But I don't believe it is the least restrictive means, because the churches, for instance, are exempt. The court, or the government rather, has decided that there are other organizations who are worthy to be exempt, and they've simply decided that our clients are not. And our clients have the same objections to abortions as these churches do. In fact, the Health and Human Services regulations explicitly state that our clients would be complying with the mandate to provide contraceptive coverage if they fill out this accommodation, whereas the language says that the churches are exempt. So our clients are being treated differently. The government itself views them as facilitating this contraception. And in fact, as I've said, Your Honor, that in fact is the case, because this form becomes an instrument under which the plan is operated. Under ERISA law, self-funded plans can only be modified by a written document. So it's really this, what I need to emphasize, Your Honors, is that it's the affirmative act of filling out that form and the fact that that facilitates contraception, and it doesn't matter so much how far the action of filling out that form is away from the actual contraception being used. And it's the affirmative act that our clients are being asked to perform here. It's not the action of third parties to which they object. So, Your Honors, I think I see that my time has elapsed. May I have a moment to conclude? Thank you, Your Honors. And so for all these reasons, we believe that the government is making value judgments about religious organizations, which is not the competence of this court. And with that, Your Honors, we respectfully request that this court reverse the lower court's decision. Thank you.
Wade?
May it please the court, my name is Benjamin Wade and I represent United Compatriots and Legal Its Allies Incorporated, the petitioner in this appeal. The appeals court decision on this matter should be reversed because of the Supreme Court's prior decision in Burwell v. Hobby Lobby. We contend that Hobby Lobby's ruling is applicable to today's case due to numerous similarities between them. Given the similarities, we contend that another standard be used to judge future cases regarding REFRA. However, before moving forward into this other standard, I will briefly remind Your Honors of the relevant facts of the Hobby Lobby case and how that is similar to the case at hand. Hobby Lobby attacked the Affordable Care Act's mandate that they either provide contraceptives or they pay a draconian fine, the words as provided by the Affordable Care Act. This is the same exact mandate with which we deal with today, where our religious companies are being forced to sign, to either sign a form that violates their religious beliefs.
Now, excuse me.
Yes, Your Honor.
Mr. Wade, you say this is the exact same issue that we're faced with here today, but wasn't the determination in the Hobby Lobby case at least talked about the fact that there were no accommodations available? And yet here today we are looking at accommodations for your clients. Is that not accurate?
It's not accurate, Your Honor, because this isn't a true accommodation for our clients.
Okay, let me be more specific. Was that not discussed in the Hobby Lobby case?
It was. Justice Kennedy did touch on the fact that an accommodation would suffice for these. However, in that case, Justice Kennedy's comments were dicta, and they were not looking at an accommodation at all. He was merely saying his own opinion, in a sense, that any accommodation might fulfill this. However, the case at hand is the same because these organizations are still given the same choice. You either violate your belief and facilitate contraceptives, or you pay a substantial fine to your company.
And once again, you say facilitate. Why do you believe that this is facilitating? Let's say we had a form that said on it, Company X, I have no objection to providing, check mark, I have no objection to our insurance providing contraceptives. Company Y, your clients, they just don't check that box. Okay? So they're not affirmatively saying anything. Why is it you believe that that is a facilitation?
Because the effect is the exact same as it is under this current accommodation. The effect is that by signing that form, whether it is offered to everybody or whether it is offered just to our clients, says that we are complying, a word that the mandate actually says, that form says by signing this you are complying with this, with the ACA's mandate, and that, again, it is an instrument under which the health care plan is operated. If you do not sign that form and you do not check that box that you oppose it, you have to pay a fine that, again, results in millions of dollars against your company because you want to follow your
You make it
religious
sound like a
beliefs.
speech issue, though.
Ooh.
Yeah.
I'm sorry, Your Honor.
You make it sound like the problem is that the government is forcing words into the mouths of your client as opposed to that there's an actual religious exercise. I mean, does it really come down to the wording that's used, or is there something else?
No, it's not the wording. As Justice Hyman said, you could change the wording, you can make it applicable to everybody, but the effect is still the same. You are you are forcing companies to choose between their religious convictions or paying a fine. This is completely wrong under REFRA, where a substantial burden.
Were there any other instances where your client manifested its religious beliefs by refusing to sign a form? I'm just curious as to whether this is sort of a made-up thing for this particular case.
Your Honor, to delve into whether or not we're signing forms or choosing which religious beliefs to choose is not.
Surely you can envision with me a situation where a religion, one that's of long-standing historical significance, comes along and says, well, our religion sincerely and emphatically precludes us from signing any sorts of forms. Well, wait a minute. All of a sudden, there's all kinds of problems with governmental operations of many types. What I'm testing here is whether this is really about forms or if it's about something else.
It's not about the form. It's the action. It is the act that we have to affirm that we sign this form, and this results in an act that violates the religious belief of our clients. The only difference between this case and Hobby Lobby is this form, which it isn't.
The way you just said that, you have to sign a form, and that results in something that offends the beliefs of your client. that someone else is getting contraception. That's what offends the belief?
No, it is the facilitation of it. We cannot, and we do not, as we stated in our brief, that we do not oppose to third parties giving these out to people. The problem is that we are part of this process that results in them getting the contraceptives to begin with.
Well, okay, but what if it were simply a matter of the passage of time? So the government says, well, if you don't certify by X date that you're going to provide coverage, then the third-party administrator has to provide it. And you are aware of that, and you know that if you don't certify that you're going to provide coverage, that third-party administrator is going to do it. Are you facilitating?
I'm sorry, could you rephrase the question, Your Honor?
Instead of signing a form, you just let the time pass. The date comes by which you have to certify. And if you certify that you're going to provide coverage, fine, you do it. If you don't do anything by that date, then the third-party administrator has to provide the coverage. And you know that. And you know, and you watch the calendar. Here comes that date. Date comes and goes, and you haven't certified. Now, the consequence is the third-party administrator has to provide coverage. Have you facilitated that coverage in the same way that you do here?
No, Your Honor, because it isn't the affirmative act that is us stating, that by signing this form, we go forward and we, again, comply with this. However, Your Honor, that's not the case that we have.
Well, no, but you're complying because you've got a choice. You either certify or you don't. You're complying, and the consequence is the same.
However, Your Honor, again, this isn't, the case in front of us is Congress's attempt to get around these beliefs that our companies have, that, again, we define the substantial burden to our company. We know what our religion is, and so therefore the standard by which these cases should be ruled in the future is on the other two components of REFRA. The compelling state interest and the least restrictive means, as my co-counsel alluded to, these aren't referenced at all in these cases at all because it's all focused on the substantial burden. The court cannot define what the religion is. Therefore, the religion is left to define what the religious organization.
No one's questioning the validity of your religion, right?
Yes, Your Honor.
But you had mentioned a couple times how this case is just like Hobby Lobby. The majority opinion from which you're appealing took great issue with that, and they distinguish Hobby Lobby on several significant ways. What do you think the most significant similarities are between this facts and Hobby Lobby?
Again, I think it comes down to the fact that it's still the same case where we violate our religion, again, by either paying for the contraceptives or facilitating the contraceptives, or we pay the substantial fine. That is the greatest similarity because Congress and opposing counsel likes to say that this is the third way out. We get to wash our hands of any doings with these contraceptives at all. But that's simply not the case. By signing the form or by paying for the contraceptives, we're being forced to violate the religion or pay for these fines saying that come from it. Again, getting back to what these cases should be dealt on is that the least restrictive means, by saying that that churches and other religious organizations get a free pass on these.
Is the form, is that the same as the notice? Or is that a different thing you're allowed to submit?
I'm sorry, Your Honor.
Isn't there a notice also you can utilize? Is that the same as the form?
You're referring to the notice to Health and Human Services.
Right.
It's the same effect that we.
Different procedure, though.
Yes, Your Honor. However,
utilize the notice procedure if you wanted to?
We could, but the end result is still the same. Hobby Lobby.
But there's no particular even requirements for that notice, is there? It's pretty. They don't tell you what the notice has to have in it, do they?
It's name, organization, however.
Vague. So for someone who's arguing substantial burden, and you fill out a notice that's really, they don't even tell you what it has to contain in it. It just doesn't seem that burdensome.
But the end result is still the same, Your Honor. You're still facilitating, whether you send in a form, a note, and a memo to the government. It's still the same.
It doesn't matter to you how far away from that act the end result is.
Yes, Your Honor.
Is that right? Shouldn't make any difference.
Yes, Your Honor, because in Hobby Lobby, they say the exact same thing. The middleman aspect, the addition of chains of links into a chain of this, it doesn't matter. You're still having the same result whether you immediately pay for the contraceptive or you add in another government entity to pay for it. It's still the same. It's still the same end result. And again, Hobby Lobby said that by getting into, by delving into the area where you're starting to count links in the chain, the government is starting to get into that dangerous territory of stating what the religion is. You're starting to say, well, you know, as long as there's 3 middlemen in between this process, then...
Well, but can't we just draw a line between financing and other? I mean, isn't that Hobby Lobby? They actually had to pay for it, right? They had to finance the contraception.
Yes, Your Honor.
So why can't we just draw a line between financing and not financing? I mean, that's an easy enough line. That doesn't have anything to do with counting intermediary steps.
Because then, again, you're stating that my religious clients believe that paying for it and not paying for it is, that paying for it is the only way that they would be violating their religion. Our religion states that any sort of facilitation is in violation of our beliefs.
Wow, but it's more substantial, though, isn't it? To actually have to pay for it?
Yes, Your Honor.
Well, okay, so that's substantial and this is not. I mean, it's a burden, but it's not substantial.
I see that my time has expired. May I respond to your remarks? Again, it is the religion stating their beliefs, not the government coming in and saying this is what you guys should believe because it's more reasonable that it stops at financing rather than stops at facilitating. And with that, Your Honors, we humbly request that the justices overturn the appellate court's decision. Thank you very much.
Thank you, Mr. Wade. All right, we'll hear now from the respondent.
May it please the court. Good evening, Your Honors. My name is Derek Entre, and I represent the United States of America, the respondents in this case. The usage of forms to certify religious objection does not qualify as a substantial burden on religious exercise. This is true for 2 reasons. 1, the completion of accommodating forms does not authorize or trigger payments for contraceptions, nor is the accommodation a vehicle for the payment for that contraception. And 2, the contract employers are required to maintain with insurers or TPAs does not promote the usage of contraceptions. Instead, by signing the forms, the objectors are removed from the process of contraceptive acquisition. Thus, the conduct the petitioners object to is not their own conduct, but rather the conduct of third parties.
Isn't the ultimate result is these individuals are getting contraceptives?
Yes, Your Honor. However, by signing this form, the religious objectors are removed from that process. They do not have to pay for it.
They'd be removed from the process if they didn't have to file a form.
Well, Your Honor, the filing of the form, without filing the form, there's no indication that not filing the form would remove their requirement from providing contraception. By filing the form, the religious objectors are able to remove themselves from the process, which is then moved to the federal government and the insurers or the third-party administrators of them.
Why do they have to file a form anyway?
Your Honor, there are hundreds, if not thousands, of nonprofits in this country, some of whom are religious and some of whom are not. By filing the form, you can, it's clear, Your Honor, that Catholic Charities is religious, but without filing the form, we may not know that something like perhaps the United Way is a religious objector to this sort of contraception. By filing the form, we can take the guesswork out of these sort of accommodations and allow for individuals for objectors to object and still further this compelling state interest of health care, Your Honor.
See, it seems to me that if we're really just talking about a form, maybe that would be easier to dismiss, but this is something more, isn't it? I mean, this is essentially bringing the TPA into the coverage plan and delegating a particular piece of that plan to them, which does strike me as something a bit more involved. It's not simply a certification, it is a delegation.
However, yes, Your Honor, and through that delegation, the objectors are removed from this process. They do not play a role in the acquisition of contraception. No information about contraception can be issued with any information about the plans from the insurers. There even has to be a letter that explicitly states that the employers do not pay for the contraception and that they object to the contraception. So by this accommodation, the employers are able to state religious objection to be removed from this process, and thus the process is...
It's an entanglement, though. I mean, you've got a health coverage plan. It's not simply walking away. It's bringing someone else into the health coverage plan to do the government's bidding that you don't want it to do as somebody who's purchased the insurance.
Your Honor, however, I think we can agree that there is a compelling state interest here, one, and that, you know, the simple...
Well, okay, so now you're conceding on substantial burden?
No, Your Honor, because the simple filing of the form, which is perhaps not what the direct objection is to, one, but the ultimate objection is to the action of third parties, and this court has held previously that RFRA does not confer a right to challenge the conduct of third parties and the actions thereof.
Well, no, but I guess the point is, you know, here you are requiring these religious organizations to be involved in the scheme. Why not just take it completely outside? Just tell those who want to purchase contraceptive coverage they have to go to the exchanges to buy it. I mean, and that way there's no form, there's no involvement with the plan administration on behalf of the religious nonprofits.
Your Honor, we feel that you know, through this sort of certification process, we can have we can split the cost more broadly to where the cost is not solely borne by one individual. You see, there are obviously many nonprofits that do not have these sort of religious objections to these contraceptions, to these methods of contraception.
So what the other nonprofits that they don't object means that the Little Sisters of the Poor, whomever else, UCLA cannot object?
Well, Your Honor, they are allowed to object, and that's why we have this accommodation. You see, through the accommodation, they are able to remove themselves from the process. They don't have to pay for it. As I said previously, their objection is stated. I mean, clearly, the Little Sisters of the Poor and UCLA here, they have no problem stating their objection publicly. We wouldn't be here today if they had such a problem with stating it publicly. So again, I reiterate that the actions that are being objected to are not the actions of the individuals. It's not the action of filing the form that they object to. It's the actions of the third parties who are providing the contraception, not the actual UCLA, not United Compatriots and Legal Allies, the entities thereof. So, as I said previously, the completion of the forms does not authorize or trigger the payment for contraceptions. It's clear that contraceptive coverage is required under the ACA. Group plans, whether offered by insurers or third parties, do have to have this sort of coverage.
How long does it take to fill out this form?
Come again, Your Honor, please?
How long does it take to fill out?
They are very simple forms. It's just a, you know, name, company, you know, who you are, who's your insurer. It's very simple information, Your Honor.
How many forms like that would an employer be required to fill out a year?
Well, Your Honor, it's you either submit Form 700 to your third-party administrator, or you submit a notice to HHS, and at that point, the federal government then takes over the process. So it seems that the filing of such a form is not, it's a one-time deal, it's a one-time shot, and then you're done. You're off the hook, and you have been removed from the process of contraception acquisition. You know, we've as the federal government, we have created this accommodation. That way we can have a middle road between the compelling state interest of health.
We had the accommodation, though, because you kind of were stuck, right? You had to come up with an alternative, didn't you?
I'm sorry, Your Honor, I didn't hear your question.
You created the alternative so you didn't impinge upon religion too much, right? Wasn't that the idea?
Well, Your Honor, it is a way to have both the compelling state interest of health care and to pay deference to religious objection. Yes, Your Honor. It's a middle road there that we can try to address both these interests and give respect to both.
No, but you're taking over the plan, right? I mean, that's the whole point. It's not just simply an external imposition of or provision of a benefit. It's you are specifically going in and hijacking the plan, the insurance plan, and that's necessary to the whole scheme, right?
Well, but again, Your Honor, the action that is taking over the plan, that is still third-party action. That's not the action of...
That's the plan. The plan is of UCLA or its members. I mean, it's about their insurance plan and the government coming in and using that to achieve its goals.
Well, Your Honor, the plans are not the vehicles by which these contraceptions are paid for. They are not the way that they're covered. As I said, the objectors do not have to pay for these contraceptives. That cost is borne by the federal government, who reimburses third-party administrators up to 115% for contraception.
But Mr. Andre, At this point, you are simply guessing, are you not, that this 115%, that extra 15%, is going to be sufficient to cover the contraceptives? You know, the petitioners had initially indicated that they didn't believe that that would be sufficient to cover it. And therefore, their clients were in some way going to be required to financially support this endeavor. How is it that you have a crystal ball such that you know that they won't?
Your Honor, it's not that we know that they won't, it's that they haven't yet. And this court is not in the business of playing hypotheticals. That issue is not ripe, as you would say. So this court, we have the question at hand of whether this is a substantial burden, not of whether these sort of costs have been passed off yet, as they have not yet. So we have seen that, you know, at least to this point, that 115% threshold has been sufficient. And should it be insufficient in the future, perhaps we can readdress this. But at this point, that 115% has been sufficient to cover the costs of contraceptive care for these individuals.
What do you, excuse me, Counsel,
Yes, Your Honor.
make of the petitioner's claim that you are triggering this payment?
Your Honor, it's perhaps not that the individuals, the objectors, are triggering this, as you say. The ACA has already triggered this sort of requirement for contraceptive care. That's already been put in place. There is this requirement. It exists. It is law. So that trigger, as you say, has already been pulled. What we allow with this accommodation, Your Honor, is for religious objectors to be removed from the process and removed from action with the trigger. So with the accommodation, you were able, the contraceptive trigger, as it were, is moved to third parties. So there is no route under RFRA to object to the conduct of third parties. And this court actually has held in previous cases that there is the independent conduct of a third party, namely the federal government, that RFRA challenges to that, religious objection challenges to that, typically fall short. We can turn to Bowen v. Roy for one example.
You think the plan has nothing to do with the payment of these claims?
Your Honor, could you actually restate your question, please?
Well, earlier we were talking about the significance of not merely the certification or the notice or whatever, yes, but also the idea that the federal government is basically saying we're going to hijack your insurance plan and use that as the way to pay these claims. And you were saying, well, the plan really has nothing to do with it. It's because it's these third parties that are paying it. Did I restate that accurately? Is that your position?
Well, Your Honor, yes, there is the plan. However, the contraception coverage is outside of the plan. Yes, Your Honor.
Well, but how would they know what claims to pay?
Well, Your Honor, while you do make a valid point that there is this information.
They have to use the plan, right?
Well, this information is passed along, and it's made the accommodation does make it easier for insurers and the federal government to know who to pay.
Easier? How else would they do it?
Well, yes, Your Honor. However, even without this accommodation, there would still be a requirement for contraceptive coverage. So with the accommodation.
Oh, yes, but that's the point exactly, right? Because what they want is what the churches get. They don't have to do anything. And here it's not enough because their plan gets hijacked to provide the coverage.
However, again, Your Honor, there are thousands of nonprofits in the United States, and allowing an accommodation allows for religious objection to occur to a given law. However, it prevents the broad usage of the ducking of a mandate. I see my time has expired. May I have a moment to conclude? For these reasons that I have stated previously, we respectfully request that you affirm the lower court's ruling. Thank you.
Thank you, Mr. Andre. Mr. Alexander?
May it please the court, my name is Adam Alexander and I represent the respondents in this appeal. I'll be addressing the second question, that Hobby Lobby does not control this case. The ruling of the lower court should be upheld for two reasons. And first, because Hobby Lobby dealt with for-profit rather than non-for-profit organizations. Additionally, this case provides religious objectors with an out that they did not already have in Hobby Lobby. And second, because the government must be allowed to maintain an organized system to operate the regulatory scheme under the Affordable Care Act.
Well, right, but subject to RFRA.
Subject to referendum.
I mean, that's the problem here, right? Congress has enacted 2 statutes, not 1, so you can't just go back to the Affordable Care Act and say it prevails.
Correct, Your Honor. I'm happy to jump to that point right now. When extending religious accommodations, the government must be allowed to provide for regularized, orderly means of permitting eligible individuals to declare that they intend to take advantage of their religious accommodation. And that's really what this self-certification under the regulation accomplishes. It does so by requiring only that employers say something that they have already proudly proclaimed throughout this litigation, that they object on religious grounds to providing contraceptive coverage to their employees. To interpret RFRA to negate even such a certification requirement would be pretty extraordinary. In this case, they are required to formally request the accommodation in order to receive it. This is not meant to be, or effectively even, a burden on their faith. Rather, it is a good faith method of ascertaining who the accommodation should be provided to.
Churches don't have to do it, though.
Churches are provided the accommodation, yes, Your Honor. That's because churches are already, through the U.S. tax code, organized, and the government can quickly identify that these are groups that will probably have religious views. For example, like a group called the United Methodist Church. We can probably tell that they're a religious organization. However, when you get into the realm of nonprofits, such as hospitals and whatnot, it can start to get a little blurrier, and the government understandably needs this form to make it easier to provide the accommodation.
Well, no matter how you've done it, you've created 2 different classes of groups that have religious beliefs that conflict with this obligation. And you treat one, the churches, one way, and you treat the other, the nonprofit charities who have religious beliefs, another way.
Yes, Your Honor, that is true. The churches are treated differently than nonprofits. However, with the simple act of a stroke of their pen, applicants can secure the exact same treatment from the government that the churches already get.
You said it's not a burden. I think that's what you said. It's not any burden. I mean, it is a burden, right? They have to do that. Otherwise, but for the law, they wouldn't have to do anything, right?
Indeed, Your Honor. There is a
burden. The question is it a substantial burden?
Indeed, Your Honor.
Because you seem to want to minimize it and say it's just a stroke of the pen and it's no burden, but it is a burden. So the question, I think, is really how much of a burden. And it does seem like that you all don't submit these forms, right? You're not required to submit these forms. Have you ever filled out one of these forms yourself? Probably not.
Indeed, Your Honor.
Right? So how can you say it's no burden at all?
Your Honor, there is a tension here. I will be completely frank about that. There is a tension here. However, as I mentioned, the burden on the religious objectors is one that is minimized and is done with respect to their religious beliefs. That it is done in a way to empower their religious rights under RFRA. It's meant to make it easier for the government to pay respect to their religious beliefs under RFRA.
How does it do that?
Your Honor, by making it easier for the government to know who exactly wants this religious exception to the law. Indeed, in Hobby Lobby itself, as the court already pointed out, the court viewed this accommodation available to nonprofits as furthering the government's interest, but not impinging on the plaintiff's religious beliefs. And that's really an important part about RFRA and how Hobby Lobby interpreted RFRA. RFRA is not meant to be this thing that defies everything that the government does. It's still supposed to advance the government's interest, but without impinging on their religious beliefs. And that's exactly what we've done here. In Hobby Lobby itself, the court said that the less restrictive means available for-profit corporations would be to treat them as nonprofit groups are treated.
Well, but now you're really getting around to the back side of the inquiry as opposed to the substantial burden step. I mean, are you?
Your Honor, yes, I'm trying to focus more on Hobby Lobby here because my co-counsel focused more on the substantial burden, but the substantial burden of
It's certainly not least restrictive means. I mean, the churches get that, right?
I'm sorry, Your Honor.
It's not least restrictive means. The churches get that.
Your Honor, this is the least restrictive alternative that is feasible for the government and balances the burden placed on the government to accommodate religious employers.
What other alternatives were considered?
What other alternatives were considered? Well, as petitioners have pointed out, the government could have treated nonprofits as they treat the churches, but then that runs into the problem that I was...
Other than that?
I'm sorry?
Other than treating them like the churches, you said it's the least restrictive means, other than what they do with the churches. What other alternatives might there be?
As far as more restrictive means, Your Honor?
Or something in between what they're required to do versus what the churches do? Is there something else? Is there another alternative?
Your Honor, I'm sorry, I don't understand the question.
Well, they have to fill out a form. Churches don't have to do anything. They just say we're a church. Is there anything? Is there middle ground between those? Is there any other alternatives to this having to fill out this form?
Your Honor, yes, and that's something that I think Judge Fisher pointed out. Another alternative that we could have approached would be to just have the government sort of figure out that these were religious employers, that these were religious nonprofits, and then treat them like that without having to make the nonprofits certify their religious beliefs. But as I was mentioning...
well, I mean, you could just say that we're not going to wrap them into the plan, right, and send them out into the market to buy it off the exchange. I mean, that's another way to do it, right?
They check a box on their tax form.
Your Honor, the form that we have used here, though, is the exact same one that Hobby Lobby, the justices, both Justice Alito and Justice Kennedy, viewed as being a less restrictive and appropriate means of furthering the government's interest without impinging on their beliefs.
But Mr. Alexander, as you frame this issue regarding Hobby Lobby,
yes, Your Honor,
wouldn't it be less restrictive if the government believes that this is a right that is so important for individuals, if they were just to allow all companies to be exempt, and then the government would pay for that portion of health care, i.e. contraceptives?
Your Honor, I would say no, because the purpose of the Affordable Care Act was to ensure that all Americans and all employees in the United States would have access to contraceptive care. That is the government's compelling interest here. To grant an exception without religious grounds would be to defy the government's very purpose in ratifying the law in the first place.
Not if the government paid for it and provided for it.
Your Honor, yes. In that sense, like, the government could pay for everything, but we assert that that is not a feasible means, not a practical looking at the reality of the situation here. That would become an astronomical, arduous task to accomplish what we believe can be done in a much more simple means. In this case, the petitioners and their clients are not required whatsoever to pay for any of the contraceptives. Now that is an out that Hobby Lobby did not already feature. That is the preferred means that the Supreme Court already expressed would be given to both for-profit and non-profit groups.
So as I understand your argument, the government wants to use this simple means to provide the contraceptives regardless of whether they're stepping on the toes of persons' religious beliefs?
Your Honor, the idea of stepping on their toes by making them say that they do have this religious belief doesn't really hold weight with any other government practices that we have. With that sort of logic, the petitioners would invalidate almost every government scheme that we have of accommodating religious objectors after requiring certification. For example, it would indicate that Quakers would not have to certify that they are conscientious objectors before being relieved of military obligation.
Would the petitioners have a draw exception to all contraceptives?
I'm sorry, Your Honor?
Would they draw exception to all contraceptives?
No, Your Honor, they draw exception to them being involved in contraceptive care.
I'm talking more specifically about the types of contraceptives that may be available by the third-party insurer.
Indeed, their clients object to a varying degree, depending on their client. Some object to all contraceptives, some object to only some. They represent a diverse amount of clients, yes. But to the point of the logic that we are stepping on the toes of the religious objectors, that same argument could be used to say that a Jewish prisoner wouldn't have to fill out a form saying that he is Jewish before being given an alternative meal other than pork.
Well, no, I mean, that's completely different because you're not talking about inviting somebody else to execute a plan that the religious objector is otherwise responsible for. I mean, this is a delegation. It's not simply a declaration that I'm religious. It's a delegation of authority under an insurance plan.
Yes, Your Honor. That is an important distinction to make. Rather than dealing with a personal accommodation here, we are dealing with a regulatory scheme. And that regulatory compliance demands a more rigorous process than merely just requesting their accommodation.
But now all you're talking about is whether there's a compelling interest and whether this is least restrictive means and not substantial burden. I mean, maybe that's where we need to have the discussion, but I mean, how can we ignore that it's a substantial burden to require a nonprofit to delegate some authority under its insurance plan to somebody who's going to pay for contraception?
Because, Your Honor, in reality, this is relieving them of having to do that. This makes it easier for the government to provide them an exception to providing that care.
Well, okay, but that's all about narrow tailoring and compelling interest. That's not really substantial burden. I mean, the substantial burden has nothing to do so much with the physical act as it does the burden on the religious exercise and the sort of the moral consequences of it.
I'm sorry, Your Honor,
the moral consequences of the delegation of authority is where the substantial burden lies, not so much on the physical act.
I'm sorry, my time has expired. May I respond? The moral consequences here, the only moral consequences here are ones that would already be carried out anyway under the authority of the Affordable Care Act. What's at issue here is a religious exception being granted, and we have provided a process for them to do that.
One more question. Is the position of the government to tell churches and nonprofits what moral consequences they ought to be thinking about?
No, Your Honor, that is not the position of the government. We respectfully request that this court affirm the lower court's decision. Thank you.
Thank you, Mr. Alexander. I believe the petitioners have reserved some time for rebuttal.
Yes, Your Honor.
Mr. Bender, as you prepare for this rebuttal, I noted that twice during your initial presentation, you referred to women receiving contraceptives. You are the only individual here today that has talked about women receiving contraceptives. Is there some particular reason why you believe that this is to be differentiated between men and women?
No, Your Honor. I must have misspoke, Your Honor. Your Honor, opposing counsel has said, nothing opposing counsel has said in their arguments changes the fact that our clients must still make an affirmative action that results in access to contraception for their employees. Furthermore, Your Honor, the opposing counsel has said that it is extraordinary that we claim that self-certification is a substantial burden on religious exercise. But what is really extraordinary, Your Honors, is that the government believes that forcing our clients to either pay substantial amounts of money or provide facilitation for contraception is not a substantial burden on their religious exercise. Also, opposing counsel spent quite a bit of time talking about least restrictive means, and the fact that tonight we're discussing at least two different possibilities that are less restrictive on our clients' religious exercise, for instance, exemption for churches or the government's willingness to pay for some of the contraception, 115% of the cost to third-party administrators. The fact that there are...
Can you envision any requirement by the government that would be less restrictive other than the churches do, which is essentially nothing?
I think, Your Honor, whatever scheme is sort of created, well, for instance, Your Honor, the government has already shown a willingness, as I said, to fund 115% of the cost to third-party administrators. So I see that my time has elapsed, Your Honor. May I conclude my thought? I think that whatever scheme they come up with has to be one in which our clients are not forced to take an affirmative action, and that is really what we object to here, and whatever scheme the government comes up with has to take that into consideration. For those reasons, Your Honors, we respectfully request that this court reverse the lower court's decision. Thank you.
Thank you, Mr. Bender. All right, we thank you for your arguments. We're going to take this under advisement. We'll take a short recess.
All rise.
Be seated.
I think we're all going to make some general comments, and then we'll announce the decision about the oralists. I would just say a couple things. I guess I'll go in the order that you argued, Mr. Bender. I thought you did a really good job. You even managed to work in some ERISA law there, which is a complicated topic, so that was very impressive. You know, you really took some tough questions, and Mr. Fisher's an active questioner, and he's no shrinking violet, and you did a really good job from addressing all the questions. So that was, you know, from my perspective, very impressive. And that's an oral argument really is designed. You got to figure the judges, they know the briefs, they're familiar with the facts. So I think your instructions talked about having a conversation. That's really what it is. It's having a conversation. It's not always the conversation you want to have. Sometimes the judges are having a conversation that you're not completely comfortable with, but you were very comfortable with it, and I was very impressed. And Mr. Wade, you were very poised. I thought that you also handled the questioning very well. I thought you were calm but confident, and I was very impressed with that demeanor, the way you handled that hot bench. Mr. Andre, also, you very good. Now you spoke a little more quickly, so you got to not get too excited, but it's easy to do. But very, very good job, and you all, including you, did a nice job summarizing at the end and making the prayer for relief. Essentially, I think you all remember to do that, and you specifically, it stands out in my mind that you did that. And then Mr. Alexander, I thought that you did a really good job. One comment I would make about your presentation, you did make some broad statements, kind of about the law or about just some really broad statements. Maybe opened yourself up to some additional questioning from the bench that you might not have gotten if you'd kind of kept your statements a little more narrow, but very confident. You seemed at ease up there. You seemed to be enjoying yourself. So again, I'll just summarize by saying I was extremely impressed by all four of you. So thank you.
Guess they're looking at me. Okay. Terrific job. Boy, you know, usually I do the semifinal round when your level of polish isn't quite what it was tonight, and it's easier to find the angles and find the weak spots. But man, suits of armor tonight, guys. Tremendous job. Really nice. Very impressed. So Mr. Bender, boy, I thought your opening was just spectacular. You got right at it. The substance of what you were saying and the way that you were presenting it, just really very impressive. On the reply, boy, you got thrown a hard one right out of the box. That's tough. I've had that happen. And there's just, you know, what do you do, right? You handled it well. You always want to try to get if you get a question like that, try to see if you can find a way to just put it into a response you like, even though you know you're getting something that to make you feel uncomfortable. Put it into the context that where it's going to do you some good. So, but and you didn't have much time on the reply either. I was looking forward to asking some questions, but I never got to. Mr. Wade, great job with the passive versus active point. I think you handled that really well. Substantively, your responses seemed to be well thought out, and just overall, I thought very confident and calm. So, great. Let's see, Mr. Andre, you took some tough questions. You handled them. That was great. Really impressed with you. And just make sure you, when you're getting the tough questions, allow yourself a minute to sort of pause for poise and articulate exactly where you want to go, so that you can head it off into a direction that you like. But you handled everything really well. Mr. Alexander, the way that you dealt with the single payer option towards the end, I thought was impressive. You were getting at some important policy distinctions that I think are actually quite relevant to the narrow tailoring analysis. It's something that substantively I have to deal with from time to time, and I'm constantly trying to persuade courts that if narrow tailoring means we have to go off in a different policy direction, that's no good. And I thought you kind of got at that, and that was impressive. So, but overall, terrific job.
Gentlemen, I want to thank you for your hard work on this. Having sat on the bench for 24 plus years, just as Justice Baker says, I would be very pleased if all attorneys would put the kind of work and effort into their presentations that you have done here this evening. One thing that we were instructed before we came out here was, if they're doing a good job, turn up the heat. If they're struggling a little bit, throw them a softball. I didn't see any softballs here tonight. In fact, Mr. Bender, the reason I asked you that question right at the start of the rebuttal is because I thought, okay, he's been so dead on, he's done such a good job. Let's just start with this little question right here and see what happens. So that question was actually simply a reflection of the kind of job that I thought that you did throughout the course of your presentation. Okay? Mr. Wade, as has already been noted, you were very good at answering questions, and I especially liked it when, instead of stumbling and fumbling for an answer, you would say, could you please repeat that? Okay? To give yourself the time to A, make sure you understood the question correctly, but I have a feeling you did understand it correctly. And B, then, to go ahead and take that time to formulate your answer. And it's a very good technique, and you showed deference to the person that was asking the question. Not like, hey, buddy, come on, can't you ask me a decent question? I don't understand that at all. But you were very deferential. I really enjoyed that. Okay, Mr. Andre, when you first started, you were so anxious. And I wondered if part of that might be, when I say anxious to get through your stuff. I wondered if part of that might be as a result of the fact that you didn't want to start getting bombarded with questions. You knew you had to get A, B, C, and D in here, and everybody else was getting hit with questions, and so you were not showing anxiousness. What I mean by that is you were anxious to get your stuff, to get your points made. Okay, that's what I mean by that. And then when the questions came, oh my goodness, you just answered them, and answered them, and answered them. And in reality, gentlemen, that is one of the most difficult aspects, is being able to be prepared and answer those questions. I was so impressed with all of you. And Mr. Alexander, once again, you have some personality here. You have some personality that shines through. Okay? Now, this is a formal setting. Okay? So, We don't want to have too much personality, but clearly it shined through, not just in your presentation, but in the way that when you heard a question, okay, it's like, oh, here we are. And in your responses. So I think that showed, I mean, you're representing the government in this instance, and that can be kind of a dull, drab job to represent the government. They're the ones that have.
I am sitting here.
They're the ones who have conviction and passion on their side, right? So, I thought you really did a fine job in handling that.
Hi. As the representative member of the faculty, it's indeed an honor to sit here tonight. As you may have noticed, I did a fair amount of sitting, less talking. Distinguished colleagues certainly handled that part of the task extremely beautifully well. And so it has been an honor to sit here. And as I hear our judges comment about the possibility of you entering into their law schools, I have to say that you're not finished at Wabash yet. So I look forward to seeing you in my classroom. So if I make a plug there, but you are, I will not speak to you individually, but collectively to say that you managed this very, very difficult, I think, assignment with such grace and purpose and study. You did it so well, and I can only express my gratitude and how impressed I am given this kind of situation. I work in the world of the stage. This space is not an unfamiliar space for me, but when I realize the kinds of preparation that I do with my students to prepare for performance, that is to say, have them memorize and learn through rehearsal how to deliver a performance, I grow to appreciate the difficulties of having to stand before this distinguished body and deliver extemporaneously at times, and to be willfully and sometimes smartly thrown off course, your ability to respond. So you honor Wabash tonight, you honor our mission, your ability to think critically, certainly there. And I see in all four of you that the cool head and the warm heart. That I greatly appreciate. So thank you so much.
Well, now it's time to honor our top advocate. And before I do, I would just say that we all truly thought you did a good job, and these decisions are always difficult. So although we will recognize one of you as the top advocate, we want to emphasize again that it was close and that we're all very impressive. But tonight, the Wabash College Fall 2015 Moot Court top advocate goes to Benjamin Wade. Like to honor all of the advocates. So, Mr. Bender, why don't you come forward? Finalist.
Outstanding job.
Mr. Andre, finalist. certainly not least, Mr. Alexander, Finance.
Would you join me in thanking our wonderful panel for their participation this evening? Each of our panelists is receiving a gavel that we engraved with their names and to help them remember this competition. And we thank you so much for educating our students and our